Hello and very good afternoon, ladies and gentlemen, wherever you are joining us from. It's a very wonderful afternoon today, and my name is Gabriel Achai. I speak right from the Secretariat here of the East Africa Law Society in Arusha, Tanzania. And on behalf of the entire team, I would like to welcome you all aboard for this very wonderful and special webinar session, our inaugural session hosted by our Maritime Law Committee. And today we are learning from our esteemed panel of experts on unlocking East Africa's blue economy, the law, business, and opportunity. Now, the maritime sector is one of the sectors that is growing fast and wide. And for some of us, like myself, who come from landlocked countries, we oftentimes restrict maritime law to the law of the seas. But there will be hearing more from our panel of experts that is moderated by my good friend and brother, Mr. Derek Odhiambo. Mr. Odhiambo is an advocate of the High Court of Kenya, a partner and founder of Odhiambo Advocates, a leading firm dedicated to providing high-quality services and exceptional representation in admiralty law. And he is here with us. He's a member of our Maritime Law Committee and also a member of our Trade and Regional Integration Committee. Derek, it's an absolute honor to have you on board. And at this juncture, I'd like to invite you to take on the discussions. We are very anxious and very happy to join the session. To all our over 100 participants this afternoon, please note that we are streaming this session on YouTube and on Zoom. So please share that link so that somebody can be So Derek, I'm handing it over to you for the next couple of hours. Thank you. Bye.
Good afternoon, everybody. I hope you can see me well from your ends, right?
Yes, Derek, we can see you. Thank you.
You can see me, yes. Good afternoon, all. My name is Derek Odhiambo. I want to welcome each and every one of you for this wonderful session, an inaugural session on the topic Unlocking East Africa's Blue Economy, Law, Business, and Opportunity. I believe that today's session, we are going to have a very good interactive session with all the attendees so that we can learn something about this quagmire of what is blue economy. The way Gabriela said that many members of the East Africa community are coming from landlocked countries. And when the word maritime law or law of the sea is mentioned, that is a very alien thing. I welcome you all and I say thank you so much, East Africa Law Society, for giving us this opportunity to express ourselves and to learn with others. Welcome, everyone. Yes, today I'm having a panelist of 4 learned gentlemen and ladies. In my first go, I have speakers whom I'm going to introduce to you. Perhaps I will allow them to say a word of introduction, then we can proceed. The first speaker is Ms. Waikwa Wamuyu. Ms. Waikwa Wamuyu is a maritime expert, an advocate of the High Court of Kenya, a practicing advocate based at the port city of Mombasa, and has a practice all over and within East African belt. Wamuyu, welcome. You may say a word before we proceed to the next.
Thank you, Derek, for the warm introduction. I also thank East Africa Law Society for inviting us to be part of this inaugural session. We look forward to presenting and also just participating in this session and interacting with all the participants. Thank you.
The second speaker, I have Ms. Hilda Omboga. Ms. Hilda Omboga is an advocate of the High Court of Kenya, a maritime attorney par excellence. She has a practice within East Africa, that is Dar es Salaam, Tanzania, Kenya, Mombasa, Kisumu, and Somali by extension. She's going to be our second speaker, talking about investment and business opportunities. Ms. Hilda, you can say a word of introduction.
Good afternoon, colleagues. My name is Hilda Omboga. I'm looking forward to interacting with you as we dive into this space of maritime. Am I audible enough?
You are audible, proceed.
Yes, I'm looking forward to interacting with you, and I hope to learn also from my fellow colleagues. Thank you very much.
Welcome, Hilda. My next speaker is going to be Mr. Joseph Oyaro. Joseph Oyaro is an advocate of the High Court of Kenya, a maritime attorney. He practices his law within East Africa and specifically matters to do with maritime disputes, cargo conflicts, amongst others. Counsel, welcome on board. Maybe you can say something.
Yes, asante sana, Mr. Derek, for giving me this opportunity. Indeed, I'm happy to be a part of this process. It is a rarely talked about subject, and I look forward to engaging with you, members and panelists, and also learning from all of you. So thank you so much, and I'm happy to be a part of this. Thank you.
Much obliged, Counsel. On to my next speaker, I have Ms. Regina Jemutai. Ms. Regina Jemutai is an advocate of the High Court of Kenya, practicing specifically within East Africa, and I say globally. Regina is an assistant director of civil litigation at Ethics and Anti-Corruption Commission, that's EACC, Kenya. She is also an expert in maritime issues. She heads the docket of the maritime and blue economy within the EACC. I welcome you, Ms. Regina. Perhaps you can say a word before we proceed. I'm not sure. Ms. Regina, are you with us? All right. Maybe I'll find out what could be the issue. Nevertheless, we'll introduce her when we can be able to reach her. I want to request that we go straight to a discussion of the day. Each speaker has been allocated 15 minutes to make a presentation. You are free to make a presentation in a manner that you deem fit. If you have a PowerPoint presentation, you can share it with members. After the 15 minutes presentation, it will be uninterrupted 15 minutes. Then after that, we are going to award at least 5 to 7 minutes for any person who has a question. I believe that this session is going to be very interactive and educative, whereby every member is going to enjoy and learn something. On to my first speaker, Ms. Wamuyu Waikwa Ikebe, the managing partner, Wamuyu Waikwa and Company Advocates. She's going to discuss with us the first topic, which is legal frameworks governing the blue economy under the subtitle Navigating Maritime Law, Coastal and Lake Resources Management, and Cross-Border Regulations. B, structuring licensing, compliance, and investment agreements for fisheries, ports, and marine energy projects. C, advancing harmonization of regional legal standards to facilitate trade and investment. Ms. Waikwa, you are welcome. The floor is yours. Teach us something. Welcome.
Thank you. Thank you, Derek. I just want to share my screen for the presentation. So let me just sort that out first. I don't know whether it's displaying well on your end.
Yes, it's
Derek,
displaying
perhaps
well.
you can confirm.
Yeah.
Okay.
Yeah,
Thank you very much. So just to begin, I thought it would be important to just sort of give some background into the blue economy before going deep dive into the legal frameworks. I just felt it was important to just set the basis and give a bit of a background into exactly what the blue economy is. So you can see that by the World Bank group definition, it's basically the use of the sustainable use of ocean resources for economic growth, improved livelihoods and jobs, while preserving the health and marine and coastal ecosystems. So it's basically how we all exploit, preserve, and regenerate the marine environment, and maintain a balance between the economic development and environment sustainability. So why the sort of drive for blue economy? Well, 71% of the Earth's surface is actually covered in water. So this is in terms of oceans, seas, lakes, rivers, and then yes, ice with the Antarctica region. So just putting it into context, really from an economic point of view, I know we're all lawyers, but it would be good to just sort of give the perspective from an economic point of view and what the blue economy holds. So it basically underpins the global economy. We have 80% of global trade taking place through the oceans. We have 500,000 people being employed in just only small scale fisheries and the ancillary activities. So, but if we look at the total level of employment, it actually goes into billions. We will later on look at the different sectors, but it actually goes into billions. So it's estimated to feed about 4.3 billion people globally, which is basically half of the world's population. The key ocean assets are valued at about 24 trillion. The potential in terms of the global potential is about 4 trillion, but currently it is doing about 2.5 trillion, which is estimated to be 5% of the global GDP. So economists have then stated that this is equivalent to the world's 7th largest economy. So that just basically shows you the economic gains we can reap from the blue economy and why there has been such a global drive to then exploit the blue economy. So then just bringing that into the African perspective and specifically to East Africa. So in terms of Africa, the fiscal returns are of the blue economy are documented to be about $300 billion per year, with about 49 million jobs. And specifically within the East African region, we are then generating about 10 billion from the blue economy. So this is according to the statistics of the UN Economic Commission for Africa. So that just basically lays the basis as to why there has been such a drive for going into the blue economy and why it is so important to the regional economies. So then just looking at it from the perspective of what are the different sectors that then now comprise the blue economy. We have coastal tourism, we have oil and gas, we have fish processing and fisheries and aquaculture, which basically form one cluster. We have oil and gas and renewable energy forming another cluster. We have marine transportation, which has comprises the ports, marine transport, shipbuilding and marine sort of technology. And then there is desalination, there's coastal protection, and marine biotechnology, which is really one of the emerging areas. And then I must say another cluster or sector is also maritime security. So just looking at, this is really looking at this from the, from a very European Union or developed countries perspective in terms of how they have then established several industries within the blue economy. So you can see they have established capture fisheries, which we are also doing quite a bit of. We have shipping ports, shipbuilding, which unfortunately is not an area that is fully developed within Africa. And more so East Africa. We have offshore and oil and gas exploration, which is also still one of the emerging areas for East Africa, marine construction, marine and coastal tourism. I think this is one area that is quite developed. Marine transport, developed marine business service. Marine R&D is one area that is not very developed. Dredging happens once in a while when we're looking at port development. And then in terms of emerging industries, there's marine aquaculture, which is, that also goes with mariculture, which is also not very developed, especially within the East Africa region, but it's something that has definitely become of interest to policymakers. Then there's offshore wind energy, or basically renewable energy. So the two of them go in hand. Marine seabed mining, which is one area we're now beginning to look at within this region. There's safety and surveillance, marine biotechnology, and the different high-tech marine services that we can get. So now really going deep dive into the global legal framework, we have the United Nations Convention of the Law of the Sea, which is basically the overarching legislation on ocean governance. It's then deemed to be the constitution of ocean governance and the law of the sea. So it covers a whole myriad in terms of how ocean everything dealing with ocean governance, but I just highlighted some key things that I feel would be relevant to this specific region and this specific discussion. So one, it defines the territorial sea and contiguous zone and its limits, the continental shelf and the high seas. It also establishes the exclusive economic zone. This is in part 5 of UNCLOS. And it establishes, and this for me is the most important specifically for this discussion. And at the beginning, I think there was a lot of, there was some concern expressed about what is the role of a landlocked country. So I think the landlord countries would be happy to note that UNCLOS actually provides very serious provisions in terms of establishing maritime rights and access, transit access to the seaport and basically to exploit the resources within the sea. And I think this is also something that as lawyers and as lawyers and basically scholars within this region need to take note of, that these two provisions, both the establishment of the exclusive economic zone and establishing maritime rights for landlocked countries, were actually something that the African group fought very, very valiantly for, and ensured that this was then included in modern maritime law. So it also provides a governing framework on conservation of marine environment, marine research, and transfer of marine technology. So just looking at the maritime zones, basically as what is established under UNCLOS. So we've seen that there's a baseline. It provides for the territorial sea, which is up to 12 nautical miles, and a contiguous zone, which is a further 12 nautical miles, bringing it to a total of 24 nautical miles from the baseline. And then this whole area of the EEZ, which is an exclusive economic zone, is basically for a country to then exploit and for a country to then exercise sovereign rights over this area. Once again, just going back to the issue of the landlocked countries, it's also important to note that that Part 5 of the UNCLOS actually then establishes an opportunity for landlocked countries to get involved in this sort of exploitation of the exclusive economic zone. So it provides for countries to enter into agreements with for the landlocked countries to enter into agreement with the coastal countries to then exploit this exclusive economic zone. Then we have this area, which is basically the extended continental shelf, which is beyond the 200 nautical mile mark. So basically what this then calls for is a country can then apply under UNCLOS to then have an extended continental shelf, which would only be up to 350. Well, not only, it's actually quite a bit of a distance, would be up to 350 nautical miles. Then anything beyond that is now the high seas. So just examples under UNCLOS of how landlocked countries have been able to exercise their maritime rights, specifically within East Africa. We have the development of various corridors. So here we have the Central Corridor, which then links the port of Dar es Salaam to the various countries within that vicinity, which is basically Rwanda, Burundi, and Uganda. So they are then supplied by the Central Corridor. Then we have the Northern Corridor, which then links the port of Mombasa to the countries within the region, which is then Uganda, Rwanda, Burundi, and DRC. It also covers a bit of northern Tanzania. Then after I'm sure you're all aware of after Eritrea gained independence, and Ethiopia then lost its maritime rights. It worked very concertedly with Djibouti to then establish the Djibouti-Addis Ababa corridor. So that then forms that linkage. And now we have the sort of new and nascent corridor, which is still not yet fully developed, and that's the Lapset corridor, which is supposed to then link the port of Lamu to Southern Sudan and Ethiopia. So just other examples of how the East African landlocked countries then have been able to exercise their maritime rights. You have the, like I said earlier, the heavy investment by Ethiopia in Djibouti's integrated infrastructure, both in terms of railway, road, having dry ports, and actually taking possession of some of the smaller ports. Then we have the Uganda's construction of the East African crude oil pipeline to Dar es Salaam. So those are some of the ways under UNCLOS that the landlocked countries have then been able to exercise their maritime rights and their right to transit. So just looking at the UNCLOS implementing agreements. So we have the 1994 agreement relating to the implementation of Part 11 of UNCLOS. This basically deals with mineral exploration and exploitation of mineral resources in the continental shelf of the high seas. So this also then, this Part 11 also then establishes the International Seabed Authority, such that anyone who then wants to, or any country that wants to then exploit minerals within the high seas area then has to apply to the International Seabed Authority to get those mining rights. And then we have the 1995 UN Fish Stocks Agreement. So its purpose is basically to ensure the long-term conservation of highly migratory stocks. So within the region, it also looks at establishing and strengthening the role of regional fisheries management organizations. So within this region specifically, we have the Indian Ocean Tuna Commission. So that's one of the regional fisheries management organizations that then take care of this part of UNCLOS, this part of implementing UNCLOS. Then we have the new kid on the block, which is basically the Biodiversity Beyond National Jurisdiction, the BBNJ agreement. This is looking at exploitation of mineral resources and genetic marine resources in areas beyond national jurisdiction. So as of last week, I believe last week Friday, I think we attained 60 ratifications. So it is now it is now confirmed that it will enter into force on 17th January 2026. So this is one of the areas in which also, again, landlocked countries can also take advantage and be able to then access the high seas and be able to conduct marine genetic research, exploit the different resources found in the high seas. So just looking at the other conventions, so those were the UNCLOS related conventions. We have several other conventions that then deal with maritime law. We have the IMO conventions on SOLAS, which is basically safety of life at sea, conventions dealing with prevention of pollution from ships. Those are the MAPL conventions, the conventions regulating the standards on training, certification, and watchkeeping for seafarers. Then we have about 10 conventions dealing with maritime safety and security, ship and port interface. So we have the Load Lines Convention, we have the regulation for collisions. So we have several agreements under the dealing with maritime safety and security. In terms of conventions dealing with prevention of marine pollution, we have about 7 conventions, like the London Protocol, the Hazardous and Noxious Substances Protocol, and basically a convention that then deals with removal of waste and oil pollution waste. Then we also have the IMO conventions covering liability or limitation of liability and compensation. So there are about 8 conventions, which also include the establishment of a damage fund, a convention on carrying nuclear material, a convention on removal of wrecks. And then we have several other conventions dealing with salvage, tonnage, and measurement of ships. And there's also the IMO strategy on reduction of greenhouse gas emissions. So this, I must say, barely touched the surface. There are several other conventions. There's also the Maritime Labour Convention, which is from the International Labour Organization, or ILO. We have the UNCTAD rules on carriage, which regulates basically carriage of goods by sea. Currently in this region, we're using the Hague-Visby rules, but you also have a move towards adopting Rotterdam rules, which is still under discussion. Then we have the UN Convention on Condition of Ships Registration. We have multimodal transport of goods, which basically regulates different modes of transport from sea to ship to, from ship to rail to road. So just regulating multimodal types of transport. We have the International Convention on Arrest of Ships, maritime liens and mortgages, and the UN Convention on Biological Diversity. And this region specifically uses the Nairobi Convention. So this just shows you that there are very, very many laws that you have to then navigate as far as dealing with different areas of maritime law. So I've taken, I appreciate that there are people from, we have our colleagues from the different countries within the region, but I've just sort of taken Kenya as an example to just show how we have then domesticated some of these international conventions in Kenya and the sort of legal framework that goes into the blue economy. So we have the Constitution of Kenya, we have the Maritime Zones Act, which then deals with the maritime zones as per UNCLOS. We have the Kenya Maritime Authority Act as a regulator of the maritime industry. We have the Merchant Shipping Act, which then deals with matters of safety of life at sea. It also deals with the commercial elements of commercial shipping. We have the KPA Act, which then regulates ports and harbors. We have the Coast Guard and Defense Forces dealing with security, Fisheries Management and Development Act, which then deals with matters to do with fishing, aquaculture, and mariculture. We have MCA, which then deals with environmental impact assessments and basically environmental management. And then for the areas around, or rather to regulate activities around Lake Victoria, we have the Lake Victoria Transport Act, and we have the ICMA, which then deals with customs management. Some of the other national and some of the other allied regulatory framework goes into climate change management, marine insurance, weights and measures, Mining Act, and Energy Act, and then there's a wildlife conservation and management, the forest conservation. So it just shows you that as you're dealing with the blue economy, that it because it comprises very many sectors, there's then also a very wide array of legislation you sort of have to navigate through. From a policy point of view, we then have the continental policy framework. So this is all guided first by the UN Agenda of 2030, but more importantly, the African Union has then come up with an agenda framework of 2063 and an integrated maritime strategy of 2050. So this then outlines the different strategies there are to then ensure that Africa becomes a very strong maritime force to deal with globally. There's also the Africa Blue Economy Strategy, the Africa Blue Economy Policy, the Charter on Maritime Security and Safety, the Maritime Transport Charter, the African Continental Free Trade Area, which is gaining traction. And then there's also the Policy Framework and Reform Strategy on Fisheries and Aquaculture, and the Mining Vision. From a national point of view, we have, as Kenya, we have Vision 2030, we have the Integrated National Transport Policy, the Ocean Policy, the Blue Economy strategy, the fisheries policy, transport policy, security strategy, transport strategy. So some of the challenges that we're then facing as a country and as a region is that there's a lot of fragmentation in terms of the approach. You have different policies, you have different sectors, and you have different legislative provisions dealing with the maritime sector. So when you're in a position that, so when you are sort of dealing with a question on how to then license or basically implement either a project on fisheries, on ports, marine energy, then there are different things that you have to look at. So the first thing that you would have to look at is the legislative framework, which then touches on the so then you have to determine whether it has an international convention element to it. So for example, if you're dealing with fisheries, then you'd have to look at the sort of project you want to then implement. Does it then touch on migratory stocks? Because then that is covered by an international convention that deals with that. And then it would also fall under the Fisheries and Management Act in Kenya or the respective country. For marine energy, you'd be looking at various legislation, which include the Energy Act and various other and then you'd also be looking at the Environmental Management Act. You'd also need to look at the regional legislation. For example, AfTA, there's ICMA, the African Continental Free Trade Area, there's the East Africa Community Customs Management Act, and then you'd have to look at your own national legislation. From a policy point of view, you would have to look at what sort of plans are there in terms there's what is called a marine spatial plan, which then determines how a certain how the maritime domain will be then used. So there will be certain areas that will be designated for tourism, certain areas designated for, say, port management, for having an EEZ. So you have to look at some of those things, including whether it's a marine protected area. You'd also have to look at the institutional framework if you're then doing something beyond national jurisdiction.
Sorry about that. My humble request, I beseech that you also consider the aspect of time. Otherwise, sorry for the interruption. Perhaps you can summarize.
Okay, will do. I'm actually on the last slide. Sorry.
Proceed.
Yeah. So sorry. So just summarizing this bit. So you would, yes, look at the institutional framework. You'd look at the investment policy. Is it a private-public partnership, or is it purely government? Because then that determines what sort of agreement you would have. Then you'd also look at dispute resolution, both in terms of the locality of the dispute and the substantive law to be covered during dispute resolution. Now, just in terms of advancing harmonization of regional legal standards, unfortunately, as an East African community, we do not have an integrated maritime and blue economy strategy, but we do have various areas of cooperation and collaboration within the region. So I've mentioned some of those, which include the regional maritime coordination search and rescue, the West Indian Ocean Marine Scientific Association. So, and just to summarize, we can borrow a leaf as the East African region from some of the other RECs. So you have SADC, for example, where they have then developed a very comprehensive blue economic strategy. And then that is then geared towards improving their fisheries governance and blue economy trade corridors. We also have the ECOWAS, which has now integrated blue economy strategy into their regional development vision. So I would say, unfortunately, that's an area as the East African community we are then lacking, but it's also an opportunity for us to then develop to develop as a region and then have a more harmonized approach to attract investment and trade. And that is the end of my presentation. Thank you very much for your attention.
Thank you so much, Ms. Waikwa. Yeah, your presentation was extremely well structured and insightful from the start to the finish. Perhaps my question, from what I picked, what are the observations or suggestions that you may have for the members of East Africa, particularly the landlocked countries? We are talking about Rwanda, Congo, DRC, Congo, South Sudan. How are they going to benefit from this large economy of East Africa, blue economy? Taking note that the East African Customs Management Act has placed in a lot of bottlenecks for traders who are playing along the East African community routes. For instance, you know what about the high taxes from the port to the destination of the cargo, and the bottlenecks in different jurisdictions.
Okay, thank you, Derek. Stop sharing. Thank you, Derek, for that. So the first thing I'd say is, just in terms of the ICMA Act, one of the very key things about ICMA is that goods in transit, and that is also a provision under both the UNCLOS and both UNCLOS and international conventions on transit of goods for landlocked countries. The one key thing is that they are not then supposed to charge taxes on goods emanating from within the region. They're actually supposed to give and provide and guarantee rights in terms of free movement of goods for transit purposes. And that's also one of the things that have also been guaranteed by UNCLOS, which, like I said, it was actually very valiantly fought for by the African group, that you're then supposed to allow. So, for example, for countries, landlocked countries that want to lay submarine cables along the EEZs of coastal countries, then they're actually where as a coastal country, then you're actually supposed to guarantee that sort of access. The other thing is like I said, they can then get into arrangements with the countries, which is guaranteed under UNCLOS, for them to then participate in the EEZs. So they can then look at how to then exploit resources and enter into some form of agreement to exploit resources within the EEZ. In terms of other areas of trade facilitation, so the coastal rights is just one element. There are also very many other water bodies. So you have Lake Victoria, for example, which can also be used for both not only fisheries, but can also be used for maritime, some form of maritime transport. And you actually have a lot of that happening. In fact, the initial meter gauge was actually envisaged to then guarantee that you then develop, I think, Kendu Bay, CO Bay, specifically for transportation of goods. So you have countries like Netherlands with the port of Rotterdam, which actually use river ports for transportation purposes. The same thing in other countries within Europe, like Germany, where you have river ports being used for maritime transportation, not just for food security. So there's a lot that can be done with both inland waterways, but more importantly, their access to the ocean and maritime rights is also guaranteed.
Thank you so much. That is well put. If there's any panel, not a panel, any attendee who has any question, perhaps you can raise your hands, or the Fraziers you can ask directly. Any question? I'm seeing a chat, let me see. Somebody is asking, anonymous attendee, does blue economy laws cover or talk about inland fishing? For example, man-made lakes. Does the law regulate what kind of fish should be kept? That's a question from anonymous attendee. Does blue economy laws cover or talk about inland fishing? For instance, man-made lakes. Does the law regulate what kind of fish should be kept? Maybe he's asking if you can keep an eye patch inside your dam, your ranch.
You have, so for example, in Kenya, you have the Fisheries and Management Act that then now regulates matters on fishing, and fishing both within the ocean as well as the inland waterways. So what it does regulate is only to the extent that you have highly migratory stocks. And if there are elements of, because one of the things when you do attract, when you open up your economy to be exploited from an economic point of view, then one of the dangers that are then faced by the blue economy is what is called IUU, which is basically the illegal, unreported, and unregulated fishing. So that form of fishing where you have, say, overfishing, then that aspect will then be regulated, because then that affects food security. But if you're then having your own sort of internal your own internal sort of hatcheries, or I would say the aquaculture and a mariculture sort of facility, then from that aspect, then the regulation would just be from the fisheries organization, unless it is a highly migratory species.
Much. If we have any question, if you don't have any question, maybe we can go to the next speaker. Attendees, I encourage that whoever has a question can type in our chat, or perhaps we can answer those questions at the end when every panelist has spoken. Now I will go to my second speaker. My second speaker is Ms. Hilda Omboga, maritime attorney. She's going to talk about investments and business opportunities. Under the subtopics number 1, structuring cross-border investments and joint ventures in maritime and coastal industries. 2, navigating contractual, financial, and regulatory considerations for sustainable business models. Number 3, showcasing case studies of successful blue economy ventures in East Africa. Hilda, you have the floor. You have 15 minutes. Please proceed.
Am I audible? I'm trying to share my screen. Or maybe, Mr. Derek, can you help me with sharing the PowerPoint that I shared with you?
Perhaps you are not audible. Maybe you can raise your voice.
Kindly, can you share the screen, or you can give me a few minutes to share the screen?
All right. Perhaps you can proceed while I'm finding a way, because I'm using the laptop and the other one is on the phone. You can proceed as we organize for that, so that you save on time. Or in short, you can just copy it in the chat. I heard Gabriel was giving directions on how we proceed on that.
I think maybe Gabriel can help me, because I shared the same with him.
Yes, Gabriel, please assist to share the slides. And any other speaker who has slides can also share with Gabriel for easy assistance. Some of us are not very tech savvy. I am personally. Yes, Hilda, let us know when we can. We can proceed. In the meantime, any attendee who may have a question to Ms. Wamui, though she has finished her session, any burning question, maybe she can even deal with it through the chat.
Hilda, I propose you proceed while we set up the slide. My colleague Elmad will share that slide shortly.
Ms. Hilda, perhaps you can proceed, then we can see the slide optics later. In the meantime, Ms. Ikego, there's a very good comment coming from Ms. Lillian on Watch. I believe that is on Watch 1 from Mombasa. She's saying your presentation was very insightful and thought-provoking. Insightful and thought-provoking presentations, Ms. Waikwa Ikego. Thank you. Lilinjeri was asking, what are some of the learning courses available for Blue Economy, whether online or otherwise? Those are reactions that are coming from the screen. And we will have time. Hilda will confirm if this, what is before this, what is being displayed on the screen is what you intended to display, to showcase to us. If Ms. Hilda is having challenges, with all due respect, can we skip to the next speaker? Then after the speaker is done, we can come back to Hilda. Gabriel, with permission, Gabriel, will you allow me to invite the next speaker so that we save on time? Let's proceed, Hilda. Thank you so much. I can see you very clearly with an angel beside you.
And I believe Gabriel has been able to share.
Yes.
Okay. My name is Zilda Mboga. I hold the Master's in Maritime Affairs, specialization in maritime law and policy from the World Maritime University, that is Sweden. I'm also an advocate. I'm going to talk about our topic today was unlocking East Africa Blue Economy Law, business and opportunities. However, as my colleague who had earlier presented stated, blue economy is a vast area that has so many sectors. So I'm going to present on one aspect of the blue economy, which is maritime shipping. So blue economy is not only a selection of isolated sectors, rather than a complex and interconnected aspect. Maritime transport builds the cornerstone of blue economy. We believe maritime transport has been there since ages, and considering it, the maritime industry and the shipping that has been there, we have very many stakeholders. Personally, I usually get also confused with the number of stakeholders who are in the maritime industry, especially if we have one person who is owning a ship, we have other stakeholders who are involved. You can see we have the legal team, the design team, we have the builders, we have the class, that is the classification societies, we have financiers, we have states, we have the port, we have bankers, we have the seafarers who are the laborers, where we have the crews, we have agents. We have an international organization that oversees the whole shipping industry, because we don't have nations that can, they can only do compliance with what the international organization, which is the International Maritime Organization, IMO. We have flag states. These are states where owners of ship come from. We have coastal states and the port states. The maritime industry has been evolving and changing as time goes by. And I believe, as we say, the maritime industry is not a one-shop industry. It's not a one-shop show. We have other aspects in the maritime industry, like the offshore energy sector. We have yachts form part of the maritime industry. And we've been having changes in the maritime industry, which are usually regulated or governed by the International Maritime Organization. Currently, digitalization is a thing in the maritime industry. We have technology. We have also cyber security issues. We have regulations that are aimed at reducing marine pollution. Marine pollution entirely does not look only at the aspect of air. We have the ballast water, we have sulfur, and we have discharge that are usually discharged into the ocean. And we believe yachts are moving cities, and the amount of pollution that they tend to emit is a lot, and they need to be regulated. As much as most stakeholders believe that the maritime industry or the shipping industry does not emit a lot of emissions, carbon emissions, and that is why they were not regulated before. But from the year 2016, we had the IMO decide on issues of having short-term and long-term goals to regulate the carbon industry. That is why now we have the new term or the new kid on the block called decarbonization. So decarbonization, we are trying to minimize the carbon levels in the shipping industry, and we get alternative fuels or sustainable fuels that are not emitting a lot of carbon emissions. Currently, we also have MAS, that is the Maritime Autonomous Surface Ship. We are intending to go crewless. That means there are 4 levels in MAS autonomous shipping. On each level, we'll be reducing the number of crews who are manning the ship until we get to the 4th level, where we are not going to have any person manning a ship, and it will be manned from offshore. So the future and the prosperous of the blue economy entirely depends on us decarbonizing the blue economy. The action plan on how to decarbonize the blue economy started in 1997, where we had the MAPOL Annex 6, which was added. And then the first IMO study was done in 2000. In 2005, we had the sulfur cap, which was also introduced to minimize the sulfur from the ships. In 2008, that is when we had the base year for the greenhouse gas reduction targets. That is where we had to have the various terms. We had the short term, mid-term, and long term. Currently, we are in the mid-term level of decarbonizing. The mid-term level, we are looking at minimizing the technical and operational aspects of the shipping industry to reduce the amount of emissions that are being reduced. We were looking at the existing ships, and currently IMO wants ships that are currently built or manufactured to have renewable energies. Building a ship and the lifespan of a ship takes 20 years. And for a ship to be built, it doesn't take 1 year or 2 years. You have to do it in phases. So even if you want to eradicate these existing ships, which have a lifespan of 20 years, that means we'll have to be looking at the existing ships. And currently we are having the carbon index identity, that is the CII, and the EXI, which is the existing ships where we are trying to minimize carbon emissions. So the current regulations and a lot of forces from the International Maritime Organization, and considering that most stakeholders who are states are members and have decided to, have decided to have the carbon emissions strategies implemented. These regulations are going to rewrite the commercial shipping industry. As much as the contracts that we used to have are old age, the bill of lading, the charters, they are still the same contracts. But with this decarbonization that is currently ongoing, we have to change the way our contracts are written and how we are going to do business in time, so that we can save on a lot of so that we can reduce on a lot of cost. So on the contractual aspects, for a sustainable shipping industry, we have matters of mediation and arbitration, which look at the chartering of a ship, carriage building and sale, finance of conventional ships, sell, purchase and financing commodities of luxury yachts and super yachts, and on renewable energy, which is also, these are also matters that are under mediation and arbitration. We have the offshore wind, contracts for building, mobile offshore units, installation of wind farms, transportation of heavy lifts, installation and moorings of turbine winds. When we look at the offshore wind, which is currently a renewable energy that we are trying to tap in, matters of mediation and arbitration are part and parcel of a contract. And in the shipping industry, any ship that is held at ground is very expensive because running a ship is very costly. It can cost like 50,000 USD dollars a day. So any ship that is on ground because of issues that are or disputes that cannot be settled, then the owner or the charterers are bearing a lot of losses. So we encourage mediation and arbitration, and currently we have organizations and institutions that are sponsoring in training of mediators in terms of maritime. There are courses like, it's called Medimare, where they are encouraging, they are called countries of the South, to get more into these mediation of maritime issues. And then currently, we've seen the Kenyan government impose a mandatory marine insurance for importers to clear their cargoes, which was effective from February 14th, 2025. And this applies to personal effect and household goods which are entering Kenya via the port. So that is another area to look at. The current regulations, that is the emission regulation on carbon intensity, for us to have a sustainable maritime industry, we have to have a binding clause for the charterers, the polluter pay principle, which is a mandatory clause where anybody who is going to pollute, they are going to pay from their own pockets. We have the transition clause, since these are new regulations, and it is good to have a clause for transition to ensure a seamless implementation of permanent rules and permanent provisions to take place. To ensure that we also minimize the problem with administration and service of delivery during transition, because charter parties are usually we usually have various stakeholders, and having that clause will save the stakeholders, maybe the charterers or the ship owners, from these regulations. We have the speed reduction clause, which should be considered because most ships usually sail at an optimal speed, and the studies that have been conducted claim that that speed, there is a lot of emission that is being done. Then we need to have the speed and performance warranties. Then the energy efficiency clause, which have never been there in the previous charter parties or contracts that have been there since old age, because those are the same ones that are used. Modification clauses, because when we look at the existing ships, that means the ship owner has to modify the ship so that it can meet the current requirements that are needed by the International Maritime Organization. And considering port states and other stakeholders who are engaged in ensuring that enforcement of the regulations are done, then we need a modification clause, because there are areas of a ship that need to be either removed, and that will have an impact on the financial and operational aspect. Then we also need to have an allocated efficiency clause, which implies that there is an adherence to environmental rules and contribute to environmental friendly maritime operation. Finally, we believe the self-financing fuel saving mechanism should be used for long-term charters. In charter parties, we have long-term and short-term, and I believe we have various types of charters. We have the bareboat charters, we have the time charters. So for us to have the self-financing fuel saving mechanism for long-term charters will save a lot of ship owners from these costs that they are going to bear. The financier can only invest in vessels with a guaranteed contract of affreightment, and there has to be a clear cost benefits and analysis model that consider both short-term and long-term charterers. The self-financing fuel saving mechanism bridges the economy initiative of a ship's technical and capital expenditure and fuel expenses. And as much as we are talking about the shipping industry or the maritime transport, we cannot avoid the ports. The ports form a vital node in the maritime transport network, and they also play a crucial role in the global economy and international trade. Port also plays a major role in the decarbonization of the maritime transport supply chain, because this is where we have ships that come to bunker, ships that come to offload and load. And the more the ships take a lot of time to bunker, we are getting that they are contributing to the carbon emissions within that port. So the port can also adopt a low carbon or zero carbon or marine fuels, because bunkering is the fueling of ships, which is usually done at the port. So if they can have marine fuels that are alternative or zero, because currently we are using fuels that have high emissions, and then they can also develop a modern and more energy efficient infrastructure to facilitate these initiatives. Currently, as of 2025, the maritime trends, we've seen Africa is becoming more loud and playing an important role in delivering the future fuels to the shipping industry. We've seen African countries and island countries be talking about the just and equitable transition. And I believe we have the wind that is currently an alternative energy source. So you need to watch out for Africa, because I believe the countries of the north have already exploited their resources. Right now, they're looking for Africa to help them decarbonize. So we have an opportunity, considering we have issues of mass that is autonomous ships. We have issues of decarbonization and alternative fuels or sustainable or low carbon emission fuels. These are areas where us as advocates can take advantage and look at. On the issue, I'll tend to go back on the issues of maritime. On maritime insurance, you'll tend to see that most ship owners tend to insure their vessels either by through the P&I clubs, which are protection and indemnity clubs. And considering that right now we have to insure every item that is on board of a vessel or a container ship, that is still an opportunity. We have seen currently Mombasa has been able to open a new port at Lamu, and also Dar es Salaam has modernized their port. That means we have to increase a higher tonnage, and that will mean there'll be an increase in our country's GDP, and that means there'll be a demand on services which can be seafarers, legal, and insurance. I think that is the close of my presentation. Maybe Gabriel can share the same later with participants, since I wasn't able to share from my end.
Oh, thank you so much, Hilda. And also, I've noted that many members are asking for slides. They want these slides for future reference. So I believe that the organizers will ensure that every attendee is going to have a copy of these slides. I leave the floor open for any attendee who may have a question to Hilda. I repeat, Hilda is a maritime attorney. She's based in the port of Mombasa, Kenya. She's an advocate of the High Court of Kenya, and you've heard from her a very insightful and provocative presentation. Is there any question? And before I move on to the next speaker, somebody was asking in the chat, he said, I would like to know from the panelists example of maritime litigation they have dealt with. I know this is in line with Hilda's topic, which number 3, which was saying, subtopic number 3, showcasing case studies of successful blue economy ventures in East Africa. This question was put up to all the panelists, although it was a topic located to Hilda. And before I allow, I can tell the person who asked the question that there are very, very many successful ventures within the East Africa blue economy. For instance, KEMFRI, Kenya Marine and Fisheries Research Institute, has spearheaded successful marine and seaweed farming in Kenya. This has employed over 2,000 farmers within Kenya, those who are farming seaweed, crabs, turtles, endangered turtles, amongst others. This is under the auspice of Kenya Marine and Fisheries Research Institute, KEMFRI. In Tanzania, we have prawn farming by Alpha Crust. This one is a very successful venture at the Rufiji Delta. It has allowed the locals to export prawns to international markets like Europe and China. This contributes to at least 2% of the GDP of Tanzania. We have the Watamu Marina National Park in Kenya. This is an ecosystem that protects and promotes local tourism like snorkeling, diving, turtle conservation programs, swimming with the dolphins. And this one sees Kenya receiving over 50,000 visitors yearly. Those are international visitors. You have not talked about local tourism, which is big. If you go to Mafia Island Marine Park in Tanzania, this is a UNESCO recognized site, which brings in around 2 million from sustainable tourism in aquaculture and marine. We have the LAPSET program in Kenya. That is Lamu Port, Southern Sudan, Ethiopia Transport Corridor in Kenya. This has opened the corridors for intertrade, maritime trade from the port of Lamu all the way to Sudan, Ethiopia. This one alone contributes 5% of the Kenya's GDP. We have seen the Djibouti's Dorale multipurpose port. This one has employed very, very many people, has opened shipbuilding industry, and is really bringing at least an annual 500,000 US dollars. Is it 500,000? 500,000 US dollars per quarter. That is in Djibouti. If for ladies especially, if you go to Zanzibar, Tanzania, we have seaweed bioproducts, conservation by Tanzania. This one, they are farming seaweed for purposes of making cosmetic products. And this one contributes to around 10 million US dollars annually into the economy of Zanzibar, Tanzania, by extension. So this is just an example of the benefits that we are getting from the blue economy. Somebody also asked a question like examples of cases that panelists have dealt with in litigation. Perhaps that will be the last question. We'll deal with it when we'll be closing so that we don't disrupt the remaining speakers. But I assure you that that question, we are going to answer it generally after the end of our session. On that account, I want to invite our next speaker, Mr. Joseph Oyaro, advocate of the High Court of Kenya, maritime attorney, and specialist. is going to discuss for us environmental and regulatory challenges under subtopic. You have 15 minutes.
Yes, thank you. Thank you so much, Derek. As I set up my device for PowerPoint presentation, I would like to note that much has been said on this subject. I was to comment on the legal strategies and also the dispute resolution mechanisms. I think my colleagues who have come before me have shared quite a lot on that subject. My presentation will therefore be quite limited on some of the issues that have not been discussed today and some of the issues that are not usually mentioned regarding our sea or our maritime environment. So more specifically on the legal strategies, before we discuss anything about legal strategies, I don't want to waste time on trying to set up this device for PowerPoint. I can just make the presentation as we try on our end to have that set up. Now, before we talk about the legal strategies, I think it's important to highlight or to note that we face a great problem, we face a huge problem at, or huge challenges at the sea that actually needs to be remedied. We need to come up with measures or policies or ways in which such issues or such challenges can be dealt with to enhance the production or the enjoyment, full enjoyment of the benefits at sea. Now, some of those challenges I'll highlight, the first would be the governance and policy challenges. This in particular relates to, for example, weak policies. Now, my colleague who actually came first mentioned or talked about the United Nations Convention on the Law of the Sea, which is a very, very critical document or convention when it comes to the issues of delimitation of the sea area. The sea, as she correctly pointed out, is delimited, and rights, the delimitation actually sometimes affects the rights of the coastal or territory or certain territories. Now, the laws applicable or the policies that are applicable in one state or in one coastal state are not necessarily applicable in another state that shares or who share the same sea. That is a challenge. Implementing such challenges when it comes, for example, to the rights of employees or workers at sea, also called seafarers, for example, might be a challenge. Remember that like any other environment, the sea also is susceptible to activities which are not in line with the law. So it is important that those people or those vessels that are at sea at any point are governed by laws. So we have various laws, but we have challenges in implementing those laws. Now, I've mentioned about seafarers, for instance. Now, seafarers are those people who work at sea. My colleague again, Hilda, talked about the flag state jurisdiction and their roles in implementing some of these rights. Now, we have a situation where, for example, that the employees or the workers at sea originate from a certain area, moving to another area, another coastal area, for example. Now, the challenge that poses is that the laws applicable that would otherwise guarantee the rights of such individuals would be a challenge if, for example, the flag that the vessel is carrying is of the state of origin. But the act that is being challenged in law has occurred at the state in which the vessel is set to land or to go. So we need to have policy guidelines to protect certain rights or to ensure that the rights of these individuals or the rights of beneficiaries of such actions actually are protected. The other challenge would be corruption. Corruption and illegal activities. Remember that we derive a lot of benefit from the sea, including fishing and so on and so on. So corruption is a major issue in very many aspects. So once, for example, we allow illegal fishing or uncontrolled fishing, then such activities have the effect of actually affecting or damaging the maritime ecosystem. So it is important for us to have controls. And it is for these reasons, I believe, that the strategies that my colleagues have talked about, including implementing or setting up mechanisms for implementing certain laws, is key to ensuring that we arrive at or resolve this challenge, very big challenge of corruption. Then also, my colleagues have talked about the environmental and climate change. Of course, that also is an issue that needs to be addressed, needs to be talked about, that the environmental and climate changes actually affect the sea. We notice that there is coral bleaching, there is ocean change in ocean currents, and so on and so forth, and that in effect threaten the marine diversity. So it is important for us actually to, in coming up with legal strategies or strategies to combat such issues, for us to look into that. Then we also have resource management challenges. And that, for example, we don't have enough data. I think the data is needed. We need to have a situation where that all that happens at sea is recorded and actually put in a way that will not or will guarantee transparency in future, or for those actually that are likely to benefit. Then there is over expectation of marine resources. There is now through unsustainable practices, say overfishing and so on and so forth. So some of these things, I think, inform my topic today, or the subject that I've given today, for legal strategies for sustainable resource use and management. My colleagues talked about the laws that are in place. I will not repeat what they have said. We have several laws. The issue is implementation of those laws. If we have implementation and enforcement of the applicable laws. Now, we have, for example, and I'll go back to the seafarers, or the rights of the workers at sea. Now, the legislation that is applicable to them cannot, again, be the Employment Act. I don't think it's fair to subject the workers at sea to the laws, to the normal laws of employment. And the reason is that the environment that they are facing is quite different from the environment that other employees are facing. So we need to have laws for the seafarers. We need to have a platform to ensure that such laws that are enacted are actually they're actually implemented and enforced to the benefit of such people who actually play a very pivotal role at the sea. And I think that without these workers at sea and without having a good environment for the seafarers, then we will not have a sustainable environment for marine activities. It is very, very important. They are very crucial aspects when it comes to marine activities and also sustainability of resources at sea. So that is also another thing that ought to be looked at in depth. So I will not mention about the laws that my colleagues have mentioned. There is the environmental impact assessment regulations. We need to, for every project or any intended project at sea or in any environment, we need to conduct an assessment. The environmental impact assessment serves to ensure that, or to prevent any further or any future tragedy, I might say, to any person that stands to benefit or actually is a part of certain projects. So we need to ensure that we have strategies or policies to conduct environmental impact assessment prior to setting up any such projects. Then we move on to the second issue. How then do we address climate change, renewable energy compliance, and compliance with international maritime and environmental conventions? Now, I must mention that we live in a state where we have allowed ourselves, and I think it's a good thing to adopt these international laws. The law, there are those that apply without going to parliament, there are those that have to go to parliament. Those laws, those international laws and conventions play a huge role once ratified in Kenya. They play a huge role in addressing some of these issues related to climate change, renewable energy, and compliance with the environment conventions. Again, most of them have been talked about by my colleagues. I don't see the need to, again, repeat myself. Now, risk mitigation and dispute management, again, has been talked about by my colleague Hilda. She has talked about mediation, she has talked about arbitration, and various ways of resolving disputes that actually arise at sea. I think it's important that we have a proper dispute resolution mechanism. Now, mediation and arbitration is in as much as they are also ways of resolving disputes. You will agree with me that those processes are a bit, they take a lot of time, number one, in as much as certain states, they tend to resolve disputes. I think we need to have a more binding, we need to have a more binding resolution mechanism to some of these disputes. Because mediation means, in my understanding, that parties are allowed to engage by themselves and come up with an agreement as to how that dispute shall be resolved. We have the ICJ, for example, which plays a crucial role in resolving these disputes. But in my experience, some of these disputes, they take a lot of time. And the reason is, as I pointed out earlier, they are interstate, not, they are between different states. So you need to find like a normal ground for resolving such disputes. Sometimes it could be hard, sometimes it could be challenging to actually find a level ground to resolve such disputes. So my thinking in all these issues is that we need to have policies, and I believe as the East Africa Law Society, we have the mandate, for example, of proposing policies to be implemented by the different arms. For example, if we as ourselves propose a law or propose a policy, it's imperative that we follow it up and see to it that it is implemented. It is actually enacted and implemented by those who are beneficiaries or consumers of for example, justice. Then, as I conclude, now the blue economy. It gives us, it actually presents, it's, in opinion, it's an emerging concept. It is something that has existed before, but it is something that is being talked about more in recent times. It was not talked about as it is right now before. So it is important, I think, that now that it's a topic that has come up, and with the energy that is being given to this particular topic, I think it's right to harmonize all these instruments. Now, you will note that we have several laws that somehow some of these laws are even conflicting. We have several laws touching on the same subject. I think it's important and it's high time that we harmonize all these laws, come up with a specific act or a specific law that deals with specific subjects at the law of the sea. I've mentioned, for example, about the rights of the seafarers, which I think is something that is often ignored. We need to have a law. We need to have a law that protects the rights of these individuals. Now, are they allowed to, for example, form unions? Are they allowed to enter into collective bargaining agreements with governments? What is their position in law? What are their rights? What rights do they enjoy on board or while at sea? Remember that we also have the high seas, and my colleague actually pointed out very, very rightly when she was first submitting that the sea is delimited. Now, when it comes to the high seas, for example, remember when you were in school, we were told that the high seas, there are no rights. It's a part of the res communis. That means that it is available for use for all. So anything happens at the high seas cannot be subjected, in my opinion, to any laws of any country, because that area does not actually, in law, is not amenable, is not for use or to be applied any law that exists. So now that is a challenge, because then all these criminal activities by either pirates or by people are likely to happen in that particular area. So we need to strengthen our policies, come up with policies. I don't think it's fair to say that some part of the sea is not subject to law for one reason or the other. The flag state jurisdiction, I think that should be the guiding principle, that when it comes to ships or when it comes to vessels coming from one direction to the other, having their flags, then that state should be liable, in my opinion, to any act or omission that occurs at sea, whether at the high seas, whether the continental shelf, whether the territorial water, and so on and so forth. We need to actually hold responsible such states for any activity that happens to anyone at the sea. Now, my colleague also talked about the contract and the importance of having a contract in dispute resolution. I agree with her. The contract is a very, very powerful document that between states, between parties, again, or between the seafarers and the vessel owners, or even their captains. We need to have contractual relationships between the parties who actually benefit from that or from the sea, so that if there is a contract, then that contract may be enforceable by any state at the appropriate dispute resolution mechanism. So I agree fully that we need to strengthen our contract laws and to have that anchored in our acts or in our laws or in our legislation. There is also the issue of regional cooperation and compliance with international standards. There are those standards, in my view, that are not negotiable. That those standards that have been set by law. That those standards that we used to call the jus cogens norms. Those rights that cannot be limited. The right to life, example, and so on and so forth. So those rights, I believe also they are applicable. They are applicable at sea, and we need to find a way of ensuring that they are not in any way violated. Now, I think the last issue that I'd like to comment on is on the issue of the United Nations Convention on the Law of the Sea and its applicability to the delimited area, more specifically the territorial waters or the coastal regions. I think the law is a bit clear. There is the law allows that any vessel, provided that it doesn't bear any ill motive, to be allowed access to any coastal states. That is what is provided for under the United Nations Convention on the Law of the Sea, which is a key pillar when it comes to the delimitation of the sea, the rights of the flag state jurisdiction, and also the rights of the coastal states. So we need also to put that into consideration, that it is very, very important that even as we allow vessels to enter into our territorial waters, that it is not, or it shouldn't be strict, because now the United Nations Convention of the Law of the Sea mandates each country or all coastal states now to allow any such vessel. It is not, in my opinion, good to mandate or to make it mandatory for states to allow any vessel that comes in their country. I think that will be all. Apologies, I was not able to set up my PowerPoint presentation in time because of time. So I noticed that you only have 15 minutes. There's also another presenter who is coming in. I think I'll end it at that. Thank you so much for your time.
Thank you so much, Council. That was a very good presentation, very educative. On my part, I have no question. Is there anybody, attendee, who has a question, or a panelist who may have a question for Council? If not, somebody is asking that anybody who has the PowerPoint to share with members. That one will be done. Everyone will get their PowerPoint presentations today. Because of time, I will move to our next speaker, our final speaker, so that we can conclude and have a brief session for interaction. Our next speaker is Regina Jemutai. Regina Jemutai is Assistant Director, Civil Litigation, Ethics and Anti-Corruption Commission, EACC, Kenya. She's going to discuss opportunities for lawyers in the blue economy under the topic, subtopic 1, advisory roles in corporate governance, project finance, and dispute resolution. 2, legal counsel on technology-driven sectors such as aquaculture, offshore energy, and maritime logistics. 3, positioning legal professionals as enablers of sustainable growth and innovation in the region. Ms. Regina Jemutai, the floor is yours. And just a disclaimer to the attendees that EACC in Kenya is an authority, a government authority, constitutionally mandated to deal with matters of ethics and corruption. So anybody who may have an issue with corruption, find a way how you are going to pacify the soul of Ms. Regina. Welcome, Council. Ms. Regina. Maybe you can say something confirming that your voice is audible. Miss Regina, we are waiting for you. In the meantime, Mr. Joseph Oyaro, as Miss Regina is getting ready, somebody is asking a question in questions and answers chat. How big is maritime law and economy in Kenya? How big is maritime economy and law in Kenya? Somebody also suggested in the question and answers that we should also find a case study in Kwale. Kwale, they are farming a lot of seaweed, which has really impacted positively on the economy of South Coast, Kwale County. Kwale County is found in Kenya along the coastal belt. I can see PowerPoint presentations to show that Ms. Regina is ready. I will pause for a second as I wait to hear your voice. From the PowerPoint, I can see Ms. Regina is going to give us an introduction, outline, lawyers' advisory roles in corporate governance, legal experts in project financing, key areas in dispute resolution, maritime dispute resolution. Taking note that most maritime contracts have a disclaimer that maritime dispute shall be subject to London Charter for Arbitrators. So if you have a dispute in Uganda, maritime dispute, or in Sudan or Rwanda, always remember that disclaimer. You can raise a preliminary objection that the dispute is subject to be heard at the London Institute of Dispute, Alternative Dispute Resolutions. As we wait for Ms. Regina, Joseph, will you tell us how big is maritime business in Kenya, if you have an idea as an expert?
I didn't get the question. You, how big is maritime business? Derek, what was the question?
Sorry, members. Ms. Regina has just informed me that she's having a technical problem where she is. Perhaps as we wait for her, she's really trying and she's having a problem with unmuting her gadget. As we are waiting for her, there was a question which was presented directly to all the panelists, Ms. Wamoyo, Joseph, Hilda. Somebody want to know, can you give us brief example of or case studies of litigation that you have handled in maritime disputes? I leave that question to anybody who has an experience with maritime litigation can give attendees an example of your experience and observation. Is there anyone who is ready? Ms. Wamoyo?
Perhaps I'll go first, Derek. I would say on my part, based on my previous employment, which was basically at the port with Kenya Port Authority, there were a number of major sort of maritime cases that we then handled that were sort of a transnational nature. So some of them included the salvage related cases where a ship would go aground, would require salvage services from the port, and then that would lead to some form of dispute as to whether it was actually a salvage operation or whether it was just basically not salvage, but just basically trying to rescue the situation. They would argue that this is not really a principle of salvage. So because of that, then there are different. We then experienced that there were different cases that there were different. There's a certain mechanism of handling salvage related cases, because then they have to fill out what is called the Lloyd's open form, which then specifies that compulsorily litigation or any form of arbitration is then at either the London Maritime Arbitration Center or the London Maritime. I think there are two. There's LMAA and there's LMAC. I've forgotten the difference between the two. So just to give you an example of the complexities that come with that. Then there was also a case on dredging. This was a ship that was, or a vessel that was then contracted by the Port Authority for purposes of dredging the sea channel for widening the channel to allow for bigger vessels. Then they damaged some undersea cables. This was around 2012. So for us in the legal department, we were then working quite substantially with external advocates in terms of representing that matter. It was handled by external advocates, but we were then working conjunctively with them, both in terms of determining what the different aspects of the contractual obligations from the dredging contract, which was based on one of it was one of the standardized FIDIC contracts on dredging. And then it also came with certain provisions because of the complexities involved in terms of where this dredging company was based. Then as far as they were concerned, for litigation purposes or dispute resolution purposes, they then preferred having the seat of arbitration being in a neutral place, which was actually, again, it was London. However, the law that was then applied was actually the law of Kenya. So anyway, basically my point is sometimes also when you're dealing with transnational sort of disputes, then you have to be cognizant of the fact that either one of the countries may not be comfortable using the other country's both laws and seat of arbitration or seat of dispute resolution. So sometimes then you have to look at a neutral country for purposes of dispute resolution. But in as much as you're looking for the neutral country, then it's also important to note that you really have to be very specific as to which law you're then applying. So if it is within countries within the East African community, I must say, because most of them have a Commonwealth jurisdiction, then you would most likely be applying common law. But sometimes you'll find maybe the contractor is, say, Chinese or Japanese. So then the sort of law or substantive law that you're then applying, they would then prefer that you then apply a neutral law. So, for example, English law, which currently is the most developed. I'm hoping that Regina may have resolved her technical issues, but yeah, those are some of the few examples that I wanted to share.
Thank you so much, Ms. Omori. Perhaps, Regina, will you say, are you comfortable now to proceed? If so, you can say a word so that we confirm if you can hear your voice. And further to buttress what Ms. Waiko has said as we wait for Ms. Regina, it's already 4:01 East African time, PM, 1 minute after 4. I will say that on personal experience, I've handled several maritime disputes, but most of them range from fraud dispute investigation. For instance, I handled one matter of the owners of MV Nabiha Queen. MV Nabiha Queen is a ship that was registered, was manufactured in Sweden, but it was flagged to Liberia. Then it was chartered to carry cargo, different assorted cargos, to India. The first port of call was India, then pick further cargo and bring them to the port of Mombasa, take 2 days and proceed to Mauritius to deposit iron bars. Unfortunately, the owners, not the owners, they were sub-charterers, because in shipping, there are charterers of the motor vessel and there are also sub-charterers who can also sub-charter the ship and transact or carry small cargoes from other people to make the ship full, so that it doesn't move when it's free. So when that ship arrived in India on time, it took cargo. However, the crew and the owners, the owner was somebody from Sweden called Captain Hafaji. They got a contract and changed the course of the ship. Instead of coming straight to East Africa, they diverted it to the port of Lahore in India. It went to carry rice and sugar. So it took around 12 days while it changed its course. So the traders, the consignees who were in Kenya, they had to move to the Admiral Court, the High Court of Kenya, Admiralty Division, to sue the owners of the ship. One of the orders that they were seeking was to arrest the ship the moment it reaches the port of Mombasa, and they were successful. When the ship docked at Mombasa, it was arrested by the court order. So the owners contracted me to make sure that the ship was released. When I look at the contract and the subcontract, I noticed that there was a mediation clause, which was stating that any arbitration, any dispute must be had at the arbitration center in London. So I raised a notice of preliminary objection at the High Court of Kenya. The court upheld my preliminary objection and said that Kenya has no jurisdiction, even though Kenya has jurisdiction to test any admiral issue that arise within the high seas However, it doesn't have jurisdiction to preside over this particular case because the matter has to go to London. The ship was released, however, on a conditional release that the owners had to pay it was 200,000 US dollars or a bank guarantee. That was a successful story because though the ship escaped, because other subcharterers were claiming that they were having losses in Kenya. Also have another matter which was called DP Wood Limited, Paul Monica, DP Wood Limited. Paul Monica was from Uganda. DP Wood is a company in this country called, where the capital city is called Ceylon. It is a company in Asia, if I remember, I will tell you. However, they had cargo that was emanating from southern Sudan. This was hardwood. There was special wood that were being exported from Congo forest, southern Sudan forest, through Uganda to the port of Mombasa to Asia. They were going to Cambodia. However, when the transporter was concerned to pick the cargo from Kampala, he took more than the agreed time. They had agreed that within 12 days, the cargo will be at the Mombasa port en route to Cambodia. Although, when the transporter took the cargo, he diverted the cargo and found a way of asking for extra amount, which was culminating up to around 20,000 US dollars. When the cargo arrived in Kenya, the transporter went and abandoned it at a CFS, Container Freight Service, in Kenya, and it disappeared with the statutory documents. The matter was litigated in court in Kenya, and the court held that the owners of the cargo, they were free to pick their cargo, subject to putting up a security in court, which was equivalent to the same amount of the cargo. The cargo is still lying at the port of Mombasa because the owners cannot afford. That is just an example of maritime disputes that I have handled. There are so many if you have time. Ms. Wamulu, there's something you want to say? Ms. Oyaro, Hilda, or Regina?
Hello, Derek.
Yes.
Hello, Derek.
I can hear you.
Yes.
This is Daniel.
Yes.
Regina is asking if you can share the slide so that she can just present it.
Sorry, because we are in the East Africa Law Society. Daniel, from which jurisdiction?
An IT personnel from Pride in Paradise.
All right.
Okay, yes.
Yeah, advice, but now we can hear Regina. She can proceed if you're using the same gadget. Then she can share yes, proceed, Regina. Share the slides with Gabriel. Gabriel is our tech savvy. Then taking note that we are running out of time, I believe that you are going to be very brief. So
what about the screen? Derek, are you able to share the presentation?
Yes, I will share with Gabriel. Then you can proceed, then Gabriel will do it for us. I'm doing it right away.
Okay. Thank you.
Welcome.
Thank you, Derek, and I'm sorry for the technical issues.
Proceed.
So, for the interest of time, I will not belabor to say to go back to my topic. My topic is opportunities for lawyers in the blue economy. Can you see the screen?
Just proceed. I can't see us yet.
Okay, so that's okay. I also had, and there. Okay, that's okay. So during the introduction, I was not able to. I had technical challenges, but as you had introduced the topic, my role is to present on advisory roles in corporate governance, project finance and dispute resolution, legal counsel on technology-driven sectors such as aquaculture, offshore energy, marine logistics, and positions of legal profession in the region. So just as an introductory remarks, in issues of blue economy, maybe this is not entirely a new regime. Traditionally, island nations always relied on maritime resources. And when it began under it was called the green economy, it has now evolved to the blue economy, which blue economy emphasized on ocean-based sustainable growth. So blue economy emphasizes on the sustainable use of oceans, sea, fresh water resources for economic growth to improve livelihood and ecosystem preservation. So as we look at the opportunities for lawyers in blue economy in the region, just to mention a few opportunities across the sectors are sustainable fisheries, shipping, port, tourism, labor issues that have been dealt largely by the presenters on seafarers. There's also academia, there's dispute resolution, both through court system and ADR. There's renewable energy, ocean governance, and biotech. So the areas of practice is vast, but what is really the issue is whether in the situation is whether we need to really interrogate the realities and the practical aspect of maritime practice in the East African region. So I'll go straight to the role of lawyers in advisory roles on corporate governance. The question that we need to ask is, as much as the legal professionals in East Africa are positioned to play these roles in transformative role in blue economy, we have both service providers and architects in sustainable innovation and governance, but who are our target clients are lawyers. Our target clients in maritime in East Africa is the public sector, being governments, the private sector, the regional bodies, the non-profit sector. So I'll just quickly scroll through issues that you can pursue in terms of governance as a legal practitioner in maritime in East Africa. So one of the things that you can pursue is the legal, as a legal provider, is the issues of ESG, which is the environmental, social, and governance standards. These include the models and climate change plans. I think this has been dealt largely by one of the presenters. And in terms of environmental assessment, even for countries like Kenya, you can be able to interrogate what can the regulator, for example, NEMA, are we in a position to explore that direction? In terms of pollution in the region, what are we doing in terms of compliance to conventions that relate to pollution, like the domestication of London Convention, and what is necessary to be done to prevent such tragedy has already been put by one of the presenters. So other areas that you can explore in terms of governance is the issue of human factor, and the labor laws has been overemphasized, that we cannot really stop overemphasizing the importance of seafarers, as it was put by Mr. Oyaro. So there's also regulatory compliance. This is a big area for a maritime practitioner. Regulatory and compliance is really arena for the lawyers, and in ensuring that this adherence to the international and domestication of the UNCLOS. And what I would like to tell the listeners is that in terms of domestication of IMO conventions, the IMO website is quite a resource for every lawyer who is practicing maritime. It is very comprehensive. You're able to see what countries have domesticated, what is pending. Other areas also is ocean governance, shaping the law as a tool for environmental protection and blue economy, knowing that blue economy is about sustainability of the use of oceans. There's also issues of building institutional frameworks for marine resource. So because of time, I'll go straight to project financing. One of the areas that I'm supposed to discuss also is project financing. So what is the role of legal experts in project financing? So in terms of to facilitate the investment and funding, largely in blue economy, what lawyers can do include arranging or funding how to support the private sector or government in funding of large-scale blue economy projects, due diligence in terms of securing finances and management of risks. So largely when you look at the legal experts in project financing, one key issue is also the role of the lawyer in negotiation of public-private partnerships. The PPPs have been discussed by the former presenters. When you look at PPPs, what will you be as a lawyer, as a practitioner, advising governments or private sector on concession agreements, investment treaties, risk allocation, and largely in terms of infrastructure. So when you look at this arena, the other issue that you can do as a practitioner in project financing is what is loosely referred to as contract engineering, procedure, and construction. So in that arena, the good question that you can ask yourself as a practitioner in terms of engineering, procurement, construction, and operation and maintenance, what is your role as a legal as a legal practitioner? What you can do in this in large scale contracts, you can advise your target client in terms of drafting and negotiating EPC and IMO contracts. You can assist in management of risk and allocation, e.g. liability, limitation of liabilities, force majeure, delays and payments of demerit where there's delays. You can also, as a practitioner, ensure compliance with the local law and international standards. That is really a key area for legal practitioners. And I will not belabor on dispute resolution because that is what most presenters have touched about. But largely talking about dispute resolution in as a key area of practice, the question is, what are these key areas in dispute resolution? What I can say is that with the increased competition for marine resources, there's also increased conflict over fishing rights, offshore drilling, and transboundary water use increase. So in terms of the areas of practice, there are many disputes that relate to maritime transport, that is cargo laws, charter parties. I think Ms. Hilda talked largely about charter parties. There are issues of insurance claims and environmental litigation. Let me say something about insurance claims. Remember, traditionally, London was seen as the center for maritime insurance since the 17th century, maybe through the traditional Lloyd's of London. So legal framework and influence in a maritime arena is governed by English law, which is a globally preferred legal system in global maritime contracts. Arbitration and legal disputes for insurance traditionally were being conducted in London. But in the present case, there are now opportunities for lawyers in terms of marine insurance with the development of cargo and marine industry. Cargo, for example, which is inbound in Kenya, must be insured in Kenya. That is the new arena that lawyers should explore. But the question that you need to ask yourself in this marine industry, in this insurance industry, is what is the value? How can you monetize this as a lawyer into a legal practice arena? So other than maritime, also there are in dispute resolution, there is also the court and ADR. In court, you can see what Mr. Oyaro talked about is the vast maritime disputes, either in court, for example, ICJ in cases like Kenya-Somali dispute. There are also ADR cases which are being facilitated by the tribunals such as ITLOS. You can see ITLOS have made so many decisions which are binding, like the South China Sea arbitration. So this dispute resolution arena is both national and international, and this is an arena that the lawyers in the region can look at it. Also, in terms of settlement dispute under the convention, the UNCLOS, you may want to be aware that any state party to UNCLOS may submit any dispute resolution on interpretation or application of the convention to compulsory settlement. Other areas of UNCLOS, there is the non-consensual dispute settlement as provided by Section 1 of UNCLOS, and also compulsory settlement. So largely looking at the procedures available to state parties in UNCLOS, you can either pursue international ITLOS as a tribunal. You can take your case depending on the client or the government to ICJ. There's also, UNCLOS also provides for arbitration under Annex 7, and also special arbitration under Annex 8. So because of time, let me rush you through the role of legal practitioners in maritime dispute resolution, which are really to just highlight a few areas that you can think as a practitioner, is to support establishment of regional forums for maritime arbitration. Now that we want to build our story in East Africa in maritime area, you may think about regional forums, advising marine business investors on the benefits of ADR over traditional litigation. Also, as a region, we may think about capacity building and training legal practitioners and judges in marine and transboundary dispute resolution, so that we can put even our courts, like Kenya, we have the Admiralty Court, but the question is it serving us as practitioners in Kenya and in the region? Also, lawyers are very critical in the drafting of ADR clauses in maritime contracts, and we have, other than charter parties, we have shipbuilding contracts and port usage contracts. And the question that I keep going back to is this role of practitioners a reality for us in East Africa to even access one shipbuilding contracts, maybe in Japan, or is it until when, as a region, we are able to do our own shipbuilding that we will access this kind of practice? Away from that, then, my other key topic that I was to address is the legal counsel on technology-driven sectors, such as aquaculture, offshore energy, and marine and maritime logistics. So let's just go straight to aquaculture. So in the arena of aquaculture, the aquaculture is much related to fisheries, and the practitioners in the region have opportunity in this sector to represent clients in all these complex transactions that include acquisitions, include real estate and financing, restructuring, which in terms of financing, we have already looked at what you can do in terms of negotiation for finance. There are also diverse legal frameworks that regulate aquaculture production and water quality, biotech, and disease control. These are also other areas of
We're losing Regina. Perhaps we can pause for 3, 4, 5 seconds as we wait for Regina to reactivate her system. I wish I could throw a question to Mr. Joseph Oyaro, although I will be patient so that we don't interfere with Regina's line of thought.
Hello, Derek,
Proceed. We can hear you now.
you can hear me now?
Yes, proceed. Sorry
Oh,
for the
thank you.
problem.
So I don't know where I was off the network, but I had finished with the offshore energy and I was going to the maritime logistics and just briefly highlighting the areas of practice in maritime logistics. So in maritime logistics, what the practitioners can do is to advise clients on legal challenges related to autonomous vehicles. I think Hilda talked largely on autonomous vehicles, digital freight platforms, and other transport innovations. So legal counsel and maritime logistics may also cover areas such as marine pollution incidents, port development, shipbuilding, logistics, and intermodal carriage. You can also offer expertise on transport, logistics, cargo claims, which cargo claims really is a large area of practice. When you go to cargo claims, you would be wondering what kind of insurance claim can you lodge? And this will stem from claims for loss of life of personal injury, claims for loss of or damage to cargo or passenger luggage, claims for pollution from bunkers, claims for wreck removal expenses, or even claims arising from damages caused by collision. And here, for practitioners, you'll be looking at the law that regulates this, like the Limitation of Liabilities Convention. So it's a lot that you can do in the area of maritime logistics. I had discussed offshore energy. I hope I was still audible at that time. So I can now proceed to, I think after that, I still have, the last topic is positioning legal professionals as enablers in sustainable growth and innovation in the region. So because of constraints of time, I'll just highlight the main areas of where you can position yourself in blue economy as a practitioner, and I'll just possibly just list what is possible. There's marine law and law of the sea, which has been talked by other speakers, mostly understanding your country and the positioning about EEZ and all these are delimitation of boundaries. Our key area is also regulatory and compliance frameworks, project financing, dispute resolution, cargo and marine insurance, combating illegal and reported and regulatory fishing. As a practitioner, you can also explore issues of maritime exploration, where you may ensure compliance with the mining codes of the International Seabed Authority. You can also venture the areas of managing cargo claims and claiming of demurrage, navigation of liability. There's quite a bit. You can also venture into academia, even as members of the bench or the bar. You may also choose to practice in the Admiralty Court where there's a chance. The other big area for people who are interested in environmental law is ocean governance, where you will be dealing about sustainable exploration and conservation of and management of oceans. So although I did not put in my presentation, I just want to run through just a few challenges and opportunities as practitioners. So the main challenges that we really face in the region is legal framework, which is really, you see, our maritime laws are stem from the colonial era. So for example, even in Kenya, our own Merchant Shipping Act, we may want to look at it. We want also to domesticate a lot of IMO conventions. Those are the areas of challenges that we need to look at. Even port and maritime administration, there are issues of vessel registration, port access, custom clearance. Those are the challenges because these are complex processes. And sometimes you realize that there's no transparency in that area. There's also, I think a speaker had talked about fragmentation of the law. There's no harmonization of the law in our East African region. There is now issues of the new era of technology and emerging areas of security and environment risk. For example, there's a time where piracy was very rampant in East African coastal areas. And there's also the new era of climate change and global warming. So those are the challenges that I see. But on a positive note, also the opportunities are there. For example, if you look at Kenya, there have been great opportunities that have come to being with the coming in of KMA, the Kenya Maritime Authority, where now Kenya, as a port state and a flag state, can do registration, ship registration. We can also, under the port state, do the foreign ships can dock in Kenya. So those are the areas to look at for opportunities. Shipbuilding locally, maybe in East Africa, we don't have much, but I know in Kenya there's a time that we've tried with the Kenya, I think, shipyard, which is being run by the military. They may not be doing big shipbuilding, but in terms of Juakali industry, it's also an opportunity. There's also an opportunity in terms of the available bilateral engagements and agreements that East Africa is in. We have bodies like the AU, we have SADC, we have East African Community, IGAD. So all these platforms gives you as an practitioner an opportunity. There are also important bodies like the Western Indian Ocean governance initiatives like WIOGI. So there's still also opportunities, but by and large, what we can do in terms of recommendation is to just modernize the maritime law, do more training, capacity building, establish our admiralty codes, harmonize the regional law. Yeah, that's it. My parting shot, I want to echo the quote by Arthur Clarke that beautifully captures the irony of our planet's name, where he says, "How inappropriate to call this planet Earth when it's clearly ocean. The fact that 70% of Earth's surface is covered by water, primarily oceans, yet we named our planet after land." Thank you.
Yes, thank you so much, Regina, for your time. That was a very wonderful presentation. It was very informative. I like how you executed it, even without visual aids. Owing to the time, there's a constraint of time. I will humbly request the organizers and the panelists and attendees that you only accord us 5 more minutes before closure. These 5 minutes, I'm dedicating it to any person who may have a question. And to open the floor, I will ask the first question, and this question will go straight to you, Ms. Regina. Yes, what are types of opportunities? What is the role of advocates in these maritime disputes? Example of opportunities for lawyers are, give us an example. Those things that lawyers can exploit. For example, you understand that even in shipbuilding, an advocate must be there to write contracts. Do we have other opportunities for lawyers? Because some of the opportunities here are for technical people who have vast knowledge on maritime issues. What about advocates as masters of law?
Thank you, Derek. So away from technical, maritime is a technical subject, but in terms of dispute resolution, it may not be readily accessible to practitioners. But remember, for example, most of us were aware of the dispute that between Somalia and Kenya. The opportunities that it presented mostly were for government, people who work with the AG, Ministry of Foreign Affairs, but even as researchers, there was still opportunities to bring forth. Away from disputes between countries, there's a lot of other areas of dispute resolution, both through court or ADR. For example, ship arrests and also representing the shipping lines. And there's a lot of business in insurance industry. And also when a ship docks and there are issues of delay, there's normally very lucrative cases of claims for demurrage. And also you can also explore such claims, for example, under the LLMC over personal injury, loss of luggage, pollution. So those are the areas of practice. But because of time, I can, when I'm sending my presentation, I can also put one slide on those opportunities because it wasn't in the slide.
Thank you so much, Regina. And because of the strict timeline that you were given, I wish to say thank you so much for that well-thought presentation. I wish to say thank you so much, Ms. Wamui Waikwa Ikegu, Joseph Oyaro. I also wish to inform the attendees that coincidentally, Joseph Oyaro was my schoolmate at Kenya School of Law, and we were in the same firm. I've not seen him for like 9 years. Today I've seen you. Thank you so much, brother. Ms. Omboga Hilda was my classmate at the University of Nairobi. So I've realized that this legal village is very small. We have all met here. It's a very wonderful coincidence. I wish to say also thank you so much for the East Africa Law Society for organizing this colloquium. Thank you so much, East Africa Law Society and its entire fraternity. On that account, I wish to say thank you so much for all the attendees. Until we meet again, Asema Kwaherini. We are going to ensure that we send all these slides to emails of all members. All attendees are going to find all these slides sent to you. On that account, I wish to say thank you so much, goodbye, and may the good Lord take care of you. Otherwise, thank you so much. Gabriel, do you have anything to say before we close?
Thank you, Derek. On behalf of the East Africa Law Society, we would like to thank you, Derek, and our esteemed panelists, Hilda, Wamuyu, Joseph, Regina, and Ms. Hilda Omboga for this very wonderful session. It's been well attended with lots of members streaming in from YouTube and Zoom. So thank you, participants, for making time to be part of this very wonderful session. And thank you for your constant support throughout the session. It's been enlightening. And for us, maritime law is something that we want members to explore as a community. So colleagues, watch out for our session on Thursday on cybersecurity and data protection in virtual hearings. That session will be coming up on Thursday, 25th of September on the same Zoom platform. So we look forward to hosting you. Also, if you are out there and you're interested in joining us for the East Africa Law Society at 30 conference in Addis Ababa, please visit our conference website at events@elsociety.org or visit our website at www.elsociety.org. On behalf of the entire team, from us to you, we wish you a very lovely afternoon and get blessed until we meet again on Thursday. Kwaheri. Bye.
Kwaherini nyote. Bye bye.